Good afternoon, and thank you for joining us for an MP webinar covering 2023 HR Legislative Update, Regulatory Alerts, and Guidance. I'm Brianna Hostler, Marketing Specialist here at MP. For those of you joining us on a webinar for the first time, MP is a full-service human capital management company. We offer a complete suite of products and services to support organizations through the entire employee lifecycle, including recruiting, HR, payroll, benefits administration, time and attendance, and compliance assistance. We support our clients with cutting-edge technical solutions, as well as proactive, reliable service and deep HR and payroll expertise. At MP, we are wired for HR and help our clients succeed by aligning their people strategy with their business goals. I am excited to introduce your presenter for today's program, Paul Carelis. Paul has over a decade of experience in the HR consulting space, working with businesses of all sizes and industries. Paul leads a team of SHRM-certified HR professionals at MP. Together, they assist clients with compliance, training, and HR guidance and support for the full employee lifecycle. Paul also spearheads MP's employee retention tax credit services. This initiative has helped thousands of clients claim over $100 million in refundable, advanceable tax credits. Just a few housekeeping issues before we get started here today. If you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen. We will be sending out the recording of the webinar later today along with the slides. And with that, I'm going to hand the mic off to Paul.
Great, thank you so much. Hello, everybody. Nice to speak with you again. This is one of my favorite topics. We do it twice a year, usually in January and July. So welcome to the summer session of the Legislative Update. As always, lots going on. That'll oftentimes shift when it comes to whether it's legislatures or agencies doing all the action. This one is a little bit heavier on the agencies and in the Supreme Court, which I'm sure you've all been hearing about, but we'll dive in a little bit deeper on those. Just a quick legal disclaimer, this is from an HR best practices perspective and not to be taken as legal advice. But what we will go over today, we will talk about the legislature, what's been going on over there, both from a federal perspective as well as several of the states. States have been keeping busy. We will dive into some of the important Supreme Court cases that have recently been decided, some with a direct impact on HR and employment law, some a little more indirect. We'll talk about the federal agencies. Department of Labor and the National Labor Relations Board have both been very busy, so we'll talk about some hot items there. We'll talk about some recent changes to state laws around the country, as well as some trends and outlook, whether it be at the state law level, as well as litigation. And as always, we'll certainly try to leave some time for any questions you may have. So as Brianna said, please do feel free to pop questions into the Zoom Q&A and we'll get to as many of those as we can. Anything we aren't able to or don't have time to answer in today's live session, we will follow up with folks and provide answers to those questions offline. All right, so first, just a quick COVID update. Perhaps someday and someday soon won't have the need to do these any longer and to kick off these legislative update webinars, but here we are. So the latest on COVID, the federal public health emergency has ended as of May of this year. So you've probably seen some changes in healthcare and other settings when it comes to the federal public health emergency mandate. That said, there are still several states, cities, and or counties that have some sort of COVID leave available to many, if not all, employees. Some of those are still for COVID sick leave that you may remember from months and years ago. Others are strictly time off to obtain vaccinations. But if you see one of the names on this list as a place where you do employ folks, you're going to want to look into that or speak to one of us to go over what is still in place and if there is a sunset date for it. So the major places that still have some variation of COVID leave, either sick or vaccine, are Philadelphia, Pennsylvania, Oakland, California, Chicago and Cook County, Illinois, the state of Nevada, the state of Colorado, the state of New York, and then Los Angeles County in California. So they do, as of this month, do still have something on the books. So you'll want to keep an eye on that and make sure you're compliant there. Also related to COVID is the COVID relief in terms of economic programs that were offered to businesses during the COVID-19 pandemic. So ERTC is still alive and well. If you haven't looked into it, it is a good idea just to at least analyze your situation and see if you may have some quarters eligible for the credit. That said, the IRS did get much more activity around the ERTC than they were anticipating. As of a recent article, they claim there were about 800,000, a backlog of about 800,000 returns. So they are working through them. It is taking several months from filing to get the credit in most cases, but they are working through those. There is unfortunately also a lot of fraud, so they're trying to keep an eye on that and devote some resources to realizing fraud. But again, it is worth looking into. There are several businesses that we continue to work with to this day that do have very legitimate and worthwhile ERTC credit claims. So if you feel you might, feel free to reach out to us and we'll be happy to help you out. In terms of the deadlines for ERTC, any credits claimed for 2020 quarters need to be submitted by April of 2024. And claims for 2021 ERTC need to be filed by April of 2025. So there is still some time to claim those credits. Just to answer the quick question that came in, yes, we will be sending a copy of the slides after the presentation today. All right. So in terms of the legislature, if you missed it, we mentioned it in our January session, but the Pregnant Workers Protection Act and the Pump Act both passed the federal legislature and were signed into law. Those officially went into effect in June. So, from a 10,000-foot view, essentially what it does is, because pregnancy isn't protected as a disability under the Americans with Disabilities Act, the Pregnant Workers Protection Act gives protections to pregnant workers and allows for accommodations to them. So if you don't already, you want to make sure your labor law posters are updated to mention the Pregnant Workers Protection Act. The Pump Act has to do with mothers returning to work who wish to express milk and giving them adequate time and space to do so. The federal legislature continues to have discussions around non-compete agreements and the validity of those. As you may have heard, and as we mentioned in the January session, the Federal Trade Commission is attempting to invalidate and ban all non-compete agreements, with the exception of when a business is acquired, that the person acquired can be prohibited from starting a similar business. But other than that, the Federal Trade Commission is looking to eliminate non-compete agreements. We're seeing other agencies also move in that direction. And we're also seeing many states, and we'll talk about some of those in a few minutes. Many states are also banning non-compete agreements or placing severe restrictions on them. So yeah, you want to stay abreast of that and those developments. At the federal level, it seems like if it does happen, it'll be a little while, and it may not happen at all on the federal level, but we will see on that. As we approach the summer months here, things start to slow down a little bit in Washington. Before you know it, we'll be in presidential primary season. So we're not expecting a whole lot to get done in terms of laws and bills and things like that from the federal government. But as you'll see in a few minutes, there's a ton of activity going on at the federal agencies: Department of Labor, Equal Employment Opportunity Commission, National Labor Relations Board, all of that. So they're definitely keeping us busy from a regulatory standpoint and HR best practices standpoint. But I don't expect to see too much groundbreaking legislation come out of the House or Senate in the coming months. Speaking of the Equal Employment Opportunity Commission, for those of you who have 100 or more employees, or certain federal contractors as well, you're hopefully familiar with the EEO-1 filing. That's an annual filing where you submit some demographic information in terms of the ethnicity of your workforce and the positions being held by those individuals. Traditionally, the EEO-1 had been filed in the spring and summer. There was recently a delay that was going to push it into July. The EEOC did just recently announce that they're actually pushing it back to fall for this year. So they're doing some updates and reshaping of their internal systems over there for the EEO-1 process. So There isn't a firm date yet, but keep your eyes peeled, and certainly we'll be communicating out to clients and those on our mailing list when the EEO-1 window will be open. So again, if you have 100 or more employees, or if you're a federal contractor, you're most likely required to file the EEO-1 each year. So keep your eyes peeled for that. All right, so let's talk a little bit about the Supreme Court. They certainly were busy as their session came to an end, I believe, at the end of June. So they heard some pretty controversial cases, did make some decisions, and those will have an impact on employment law going forward. So I wanted to highlight a few of those. The first was in regards to religious accommodation. So this is one we've talked about in one of our previous webinars, but I'll refresh everyone's memory in case anyone missed it or forgets about it. So that was Groff versus DeJoy. So this had to do with a worker from the United States Postal Service, a mail carrier. This mail carrier was religious, belonged to the Christian faith, and historically, a lot of postal workers were not required to work on Sundays. But with the advent of e-commerce, Amazon, and the like, the Postal Service started going into business with some of those providers and delivering packages on Sundays. So as that came about, this employee made a religious accommodation request to not have to do the Sunday deliveries because he wanted to worship at his church. And at first, the Postal Service was able to accommodate that, find other people to do it. But as the economy and job market tightened, and as they were less than fully staffed, they started requiring him to come in to do the Sunday deliveries. And when he didn't, he was disciplined. So this case went through the courts and eventually landed at the Supreme Court. And in the Supreme Court's decision a couple of weeks ago, they basically sided with the employee, saying that that was a valid religious request, and that in order for a religious accommodation requested to be denied, whether it be in this or a similar situation, the business is required to truly and really show that whatever that accommodation, if they were to grant it, is going to cause a truly undue hardship on the business, and be able to outline that. If it's just a minor inconvenience to the business, then the expectation is that they'll accommodate it. You really have to paint the picture that without this person there at this time, or whatever the religious accommodation might be, that you have to show that it's going to be fairly crippling to the business to not have them there. The next has to do with unionization. So this was Glacier Northwest versus the Teamsters Union. Glacier Northwest was a blue collar company. And basically what happened was some employees went into work one day, and according to the case, were allegedly knowingly going to go on strike that same day. They fired up the concrete mixer and the cement mixer and all that, got the trucks going, and then decided to walk off the job, damaging some of the equipment, damaging the supplies and wasting some of the supplies, and causing a financial loss to the company because they went in, got everything running, and then left. So the question was, were those activities by the employees protected as their rights to unionize and to strike? Or, can Glacier go after these people or after the union for causing damage to their business? So there were a couple things that needed to be weighed on by the Supreme Court in this case. So first of all, the Supreme Court did give the National Labor Relations Board, who oversees kind of unionization efforts and strikes and things like that, they did keep that in their overview and purview that, yes, the NLRB still oversees employees' rights to collectively bargain and unionize and strike and all of that. So that's still protected. That said, they did also say that when something like this occurs and there's some malicious conduct, that the company does have a right to sue for those damages, and that isn't protected activity when you do harm or damage to a business. So kind of a two-sided decision there. So employees may still organize, and the National Labor Relations Act is still very valid, but there are limits to it in terms of destruction and causing expense to a business. Next is affirmative action. So this one captured quite a few headlines, and this specifically had to do with college admissions. So there were a couple of different universities that had a lawsuit, one of them being Harvard University. And as you probably know, the Supreme Court's decision essentially eliminated affirmative action in higher education. So you might be asking, why are we talking about this when we're talking about HR and employment law? Well, this is kind of what we talk about when we say indirect impact. So while we may not be worried about college admissions and affirmative action there, the way the decision is written could very well carry over into affirmative action policies in businesses for hiring employees, or DEI initiatives that give preference to certain candidates and not others. So if you do have anything in place, especially when it comes to your hiring and recruitment practices that you feel is at least somewhat aligned with an affirmative action type program, you're probably going to want to run that by legal counsel in light of this decision. Again, there hasn't been a specific case on this, but as I always say to my clients, it's best not to bear the expense of being the test case for these things. So always wise to have a conversation with an HR professional, legal counsel, to see if there's any or how much exposure there might be to the program you currently have in place. There was also another case we were curious to see if they would take and curious to see what their ruling would be, but they declined to hear the case, and that had to do with whether or not gender dysmorphia is considered a disability under the Americans with Disabilities Act. So they did not hear that case. We'll see if there's a similar one that comes and is proposed for the next Supreme Court session, but as of right now, they did not take on that specific case. All right, so speaking of the NLRB, they have been very busy. Obviously, they're dealing with that Supreme Court decision we just talked about. So they were in one sense empowered to continue to do what they're doing, but with some limitations in terms of not creating, a crime scene in terms of destruction of property or things like that. So they'll probably have some comments and some guidelines around that upcoming. They have weighed in on several other HR aspects. So the first of which is severance agreements. So this was a few months back, but there was a case where that they heard involving a severance agreement, and more specifically a non-disparagement clause. So you see these oftentimes in a release of claims, that in exchange for a severance payment to an employee, that employee signs a release of claims that essentially waives their right to sue their employer for wrongful termination or discrimination. And oftentimes you'll also see a non-disparagement clause that says both parties agree to not disparage one another or say anything ill of the other party. So in this specific case, the non-disparagement clause was just very broad. It didn't go into specifics or have any boundaries or context. They determined that that was unlawful, that trampled on the employee's protected concerted speech rights, that severance agreement was null, or the release of claims was null and void because of that non-disparagement clause. So if you do employ releases of claims and do severance payments and severance agreements, you're going to want to review those documents to make sure and see and maybe chat with a professional to see if you have a non-disparagement clause, if it's too broad and if it needs to be reworked, or if it poses some risk to your release of claims. So you definitely want to review any severance agreements you're currently using. On the non-compete side, so yet another agency weighing in on non-competes. On May 30th, the general counsel of the NLRB, which is a very powerful position, that's currently held by Jennifer Abruzzo. So basically the general counsel decides which cases the National Labor Relations Board is going to hear. And if you've been with us for the years on these webinars, you've probably noticed the pattern that when a president from a certain party takes office, the National Labor Relations Board under that administration will kind of follow that president's agenda and change, some of the employee and business rights in accordance with those policies. And then when the White House overturns and the other party takes over, you see a shift, and they'll hear similar cases and kind of reverse those previous board's decisions. So it's just a constant back and forth. No different with this. the general counsel decides which cases they're going to hear. So oftentimes they'll look for cases that they want to weigh in on, especially ones that are similar to a previous case that they kind of want to reverse. So anyway, on May 30th, the general counsel released a memo to all of the kind of satellite and regional NLRB offices stating that their stance and the NLRB's stance is that non-competes are generally unlawful, and they should be treated as such. So how much power that ends up having in terms of non-compete agreements remains to be seen, but it was a pretty clear and powerful message from Ms. Abruzzo and from the NLRB. They also weighed in on a case having to do with employee outbursts and available discipline or termination for employees who have potentially inappropriate outbursts in relation to their employment. So again, this is another one that's gone back and forth from the Obama administration ruling to the Trump administration ruling and now to the Biden administration ruling, which reversed course on one of the previous ones and basically says that when an employee has some sort of outburst and there's the potential for disciplinary action, that the employers are required to take the context of the activity into account. So not just assuming and applying the normal workplace rules to whatever the outburst was, but taking it in the context. So if it was in response to what the employee feels is an unfair labor practice, or has to do with them complaining about the conditions of their work, for instance, things that would be protected by the National Labor Relations Act, those may be protected on behalf of the employee. Obviously, the severity and the potentially vulgarness of the situation and the effect it has on other people may also be taken into account, but basically this ruling gave more leeway to employees to exercise their rights, say how they feel in relation to their working conditions, and sometimes cross some lines where in other situations there might be a disciplinary or terminable offense that it might not be so if it's in this context. Further reversing decisions, they've also recently weighed in on independent contractors. So in this case, this had to do with the Atlanta Opera, and more specifically the makeup and hair artists that work for the Atlanta Opera. Historically, they have been paid as independent contractors and paid as a 1099, which means in the context of the NLRB that they're not employees and not in a position to unionize. The National Labor Relations Board in this instance said that unlike a previous NLRB decision on similar facts, that entrepreneurial ability shouldn't be the most powerful argument, that the worker's ability to make money and do similar work elsewhere isn't a powerful factor when it comes to determining whether someone's an independent contractor or an employee, that really the control is the primary and predominant factor that should be considered. So how much control the employer has over the worker in terms of how the work is being performed, where, when, and the like. So the matter of control is what's most important. And in this specific case, they found that those makeup and hairstylists for the Atlanta Opera were under the control of the Atlanta Opera and therefore are employees of Atlanta Opera. So should be treated as W-2 employees and also have the right to collectively bargain if they wish to do so. So again, you see independent contractor coming up with several agencies as well as in several states. We'll be talking about the Department of Labor's view on that momentarily, but in the meantime, the NLRB's factors, and there's not one factor that if you have that, you're automatically good or automatically bad, but it's more of a shift of prioritizing of the factors. And basically entrepreneurial control is lowered and overall control by the business on the worker is raised to the top. And then finally, in terms of the joint employer rule, so joint employment is when two or more companies kind of share responsibility and liability for a worker. So the NLRB has proposed their joint employer rule, and basically their overall stance is that whenever two or more companies share or co-determine the terms and condition of someone's employment, so whether that be the rate of pay, the hours, the shift, the policies. If there's shared efforts on that, then there may be a joint employer relationship, and the actions of either of those employers may cause some liability for the other. So this is potentially a hotbed. We'll wait and see the final rule when it comes out. It should be coming out in the coming months. But the proposed rule suggested that the bar was fairly low in terms of joint employer in the NLRB's mind. But once we get our hands on the final version of the rule, we'll be sure to share that in an upcoming webinar. All right, so our friends at the Department of Labor, the big thing we're waiting on from them are changes to the Fair Labor Standards Act and the overtime rule. So they have announced that those will be coming out next month in August. It remains to be seen whether they will simply change the minimum salary amount that exempt employees need to be making on a weekly basis to be exempt from overtime. They could very well also delve into the job duties tests to say that, for instance, under the administrative exemption, employees need to spend X percentage of their time doing exempt duties. We don't know yet whether they'll get that granular or if they'll just raise the salary amounts. So more on that next month. They're also in August going to be releasing a new fiduciary rule. So that has to do with retirement plans and advisors and their role and responsibilities when it comes to retirement plans. So again, that'll be coming in August as well. They have an independent contractor rule of their own that's going to be coming out soon. So it'll be interesting to see how strict they get with that and how much leeway there will remain for businesses to bring workers on as independent contractors rather than as employees. That should be coming in the coming months as well. Over in OSHA, Occupational Safety and Health, that is a subset of the Department of Labor. They've got a few agenda items that they're working to get in before the end of the year. The first are guidelines on workplace violence in the healthcare industry. They've seen a spike in occupational injuries and workplace injuries due to violence, especially in the healthcare space. So they're going to be releasing some standards on that. There's also some much anticipated guidance coming on heat illness prevention. That's becoming a widespread problem, especially in the southern states and warmer climates. So they're looking to address that. That's one of their top priorities. And then it might sound a little silly given what we were talking about at the top of the webinar, but they have promised and still intend to deliver the COVID-19 OSHA guidelines for healthcare settings. So if nothing else, this will provide a good blueprint should there ever be a similar event or pandemic that occurs in terms of how it should be handled in healthcare environments to protect us, most especially the workers, healthcare workers, and to have standards that are fairly universal within the healthcare industry. So that is going to be coming out in the next couple of months. In terms of what we're seeing, we are seeing a very busy year from the Department of Labor in terms of auditing businesses. So the most common from what we've seen in working with other businesses and reading and hearing experiences from businesses out there is that there's a lot of focus on child labor and the child labor rules, making sure that employers who do bring in and employ minors are following the rules in terms of the hours, the amount of hours they're allowed to work, the time of day they're working, and their job duties. And they're looking at that pretty carefully. So if you are a business that does employ folks under the age of 18, you're going to want to make sure that you are in compliance, both at a state and federal level, as the state child labor laws can vary quite significantly. But do make sure you're in compliance there, because we're seeing a ton of audits, both from the Federal Department of Labor and also with state departments of labor as well. All right, let's shift over to state law. So one of the state laws grabbing a lot of headlines this summer is Florida's mandatory E-Verify law. So that went into effect this month. Does not apply to existing employees, but for employers with 25 or more employees that are doing business in Florida, they are required to do the sign up for and utilize the E-Verify system for new hires that they have in Florida. So basically what that is once the I-9 is completed, running that information through the government's E-Verify system, there are some pretty stiff penalties for businesses who do not comply with this law. It is somewhat controversial, but it is in some other southern states as well. But it is the law of the land in Florida as of today. So if you do have employees in Florida and hire in Florida, if you're of that size, you do want to make sure you're signed up and utilizing E-Verify for your new employees in the state of Florida. Tennessee is also another state that's had that on the books for a while and has recently made it more strict. So always a good idea to review the states you have employees in to make sure you're compliant with this and really anything else. Over in Colorado, they're going to have what's called family leave starting next year. It's similar to a paid family medical leave program like we see in New York, Massachusetts, California, and other states. So the ability for employees to take family leave doesn't begin until 2024. But this year, the employer and employee family tax to fund that program has started. So if you do have employees in Colorado, you most likely have seen a new tax and also had to complete a new tax registration to have an ID number under the family program, but that's brand new in Colorado and will kick off in terms of leave next year. Reminder for those doing business in New York, the New York pay transparency requirements are going to be kicking in September. So you get a couple months there before you need to be in compliance with that and have salary information on your job postings for New York. Also, more recently, New York is the newest state to pass a ban on non-compete agreements. So feel free to speak with us about that, but that was just passed and will be going into effect soon. On the topic of child labor, while departments of labor at the federal level and across the country have been cracking down on child labor laws, a couple of states have taken measures to slightly roll back their child labor requirements, sometimes eliminating parental permission slips and things like that. But Arkansas and Iowa are the latest to make modifications to their child labor laws. Minnesota will also be jumping on the paid family medical leave bandwagon, but not until 2026. They also legalized recreational marijuana this summer. Also in Colorado, they've made some changes to the information that's allowed to be asked on a job application. So if you utilize job applications and hire in Colorado, make sure you familiarize yourself with the do's and don'ts there. They've made a few significant changes in terms of the information that can be requested on the job application. New York City has put in some restrictions on using artificial intelligence in the hiring process. If you do decide to use AI in your recruitment and in your ATS, that software needs to be certified, and there's also some required disclosures for using artificial intelligence. The main concern is that, that artificial intelligence has a chance to be biased in its selection process. So you just want to be mindful of that. Familiarize yourself with the New York City AI law and make sure that whatever you're using, if it does utilize AI, that is disclosed and is compliant with the requirements in NYC. Over in Washington State, they've added some new whistleblower protections. So for employees who come forward with a ethics concern, that there are additional protections for employees in Washington State. They've also revamped their background check system in terms of what's going to come up on background checks in Washington State in terms of the time and type of crimes that will show up on those. And then they've also added some protection in terms of employee privacy and when an employee's vehicle can be searched. So there's restrictions now on that in Washington State. Not to be forgotten, New Jersey. So they're doing a really big overhaul of their unemployment system and their unemployment division. The biggest thing that's upcoming in New Jersey when it comes to unemployment is that once this takes effect, employers in New Jersey, whenever they discharge an employee, are going to have to report that to the state agency. There's going to be a reporting mechanism and some guidelines there, but going forward in New Jersey, once this takes effect later this year, whenever an employee in New Jersey is discharged, that is going to have to be reported to the unemployment agency. So big change in process and procedure there. All right, so looking ahead. So what are we seeing in litigation trends, and what do we intend to see in litigation trends in the coming months and year? So we're definitely seeing many more states add protected classes to their laws. So additional protections for people based on their ethnicity and hairstyles. That's under the Crown Act. More protections for folks with disabilities. Definitely more cases in terms of accommodations. We're seeing a ton of accommodation requests from employees, especially around mental health issues. We recently did a webinar regarding accommodation requests. If you missed it, you can go to our website and see the recording of that. It's a really hot issue right now. Also, many states adding gender identity along with those who haven't yet as a protected class in their state. And then also pregnancy protection. So obviously the federal law is paramount, but many states are, if they haven't already, adding pregnancy protections for their workers as well. Also seeing a lot around remote work that seems like it is here to stay for many businesses and industries. A lot in terms of wage and hour when it comes to remote work. So for remote workers who are working from their home, what time needs to be compensated? So far, a lot of the onus has been on employers to really know and be able to control when their employees are working, and if they're allowing their employees to work, even if it isn't quite authorized, but they're allowing it to happen, that's often compensable time. So got to be really keep a close eye on your remote workers, especially if they're non-exempt, because so far the rulings have been pretty generous to employees who have done things that could be considered compensable or work time. And then we're seeing a lot around leave. So again, more and more states are adding paid family medical leaves, which may or may not coincide with FMLA leaves. There are other leaves popping up around domestic violence and mental health, allowing mental health days to be used as sick time, things like that. So a lot with leaves of absence. Certainly, if you're ever considering disciplining someone or laying someone off who is currently on leave or who was recently on leave, you definitely want to consult with a HR professional or legal counsel, as there are many protections to employees, whether they be on leave or recently have been on leave. And so you want to be very mindful of that because we've seen a lot of cases go sideways there. All right, so some things to look out for between now and our next legislative update in the winter. Certainly stay tuned to MP. We send out communications and emails and do more focused webinars on some of these topics as they pop up. But some things to keep your eyes peeled for. The DOL announcements coming in August and fall. Again, that's going to have to do with overtime, the fiduciary rule, and independent contractors. Many state legislatures, as of right now, are kind of in their end of the legislative session frenzy. So kind of trying to get together, vote on some key bills. Sometimes some things will slip through at the end of the session that can be significant when it comes to employment law. So keep your eyes peeled there. We'll see if anything gets done at state house level. Also keep your eyes peeled to see what's going to end up on the ballot as ballot questions in the fall. Oftentimes those can impact employers and HR departments. As much as the National Labor Relations Board has been doing with the things we've been talking about, the severance agreements, the non-compete agreements, the employee outbursts and all of that, there hasn't been as much activity from them on handbooks, but historically that has been a hot button item for them in terms of policies and whether those policies are chilling to an employee's rights under the National Labor Relations Act. So definitely keep your eyes peeled to see if the NLRB weighs in on a business's handbook and what we might be able to take away from that. We're also awaiting some updated unionization data. So over the last few years, we've definitely seen a spike in unionization campaigns and elections and overall union employees, which had been at all-time lows over the last 10 years or so. So that's definitely been on an upward trajectory. It seems just observationally that that seems to be slowing down a little bit, but there will be some data released soon from the NLRB that will give us an idea for what that actually looks like. And again, as we said before, with that recent Supreme Court ruling on affirmative action, you're going to want to make sure that you keep a close eye on any of your DEI programs, especially if they have to do with the hiring or promotional process at your workplace, to see if they might run afoul of the Supreme Court's thoughts and decisions on race-based admissions and things like that. All right, so it looks like we've got a few questions here. In New York State, if you use an employment agency, how does it affect the pay transparency posting requirement? Well, certainly the agency will be on the hook to be compliant with those rules and regulations. And if you're hiring in New York, I would have to believe that they're going to be compliant with that come September. I know even for folks who use in-house and use an applicant tracking system or a software, many of those softwares are designed that based on where you're posting the position, if it's a position in New York, starting in September, it's not going to let you post the job without having that salary range in there. So whether or not it's considered a joint employment scenario and whether or not that liability would be shared, I'd say certainly if the company name isn't being disclosed, then you're probably a little bit protected. But if your name is out there, if you're using a recruiting service, but your company's name is out there and you're hiring in New York and not following the pay transparency rules, that could be harmful to your business. So I would make sure that any agency that you're using is following those guidelines. New York pay transparency. So there was a law passed. The law was passed last year. So there's a question there, and there have been various requirements and things like that. But the actual hard requirement statewide in New York to have that disclosure on the job postings doesn't begin until September. I believe it's September 15th. So much like many laws, especially at the state level, it takes some time to fully roll out. So this is really the most significant piece of that. And that starts in September. Okay, and then there's a question about that New Jersey unemployment rule. So that's brand new, that just passed. And there are some detailed questions here from the attendee. So what we can do is put together a little bit summary of the New Jersey unemployment regulations, and we'll send that out along when we send out the slides. Is there a grace period for E-Verify? So I'm assuming this is in regards to Florida. That is the law of the land as of July 1st. I do believe there was some language in that bill that they were going to start enforcing it next year. But to play it safe, especially in the current political and enforcement climate out there, I would as soon as possible, and it doesn't take a terribly long time to register for E-Verify, that if you are employing folks in Florida and you meet the company size requirements, that you should start using E-Verify sooner rather than later for those Florida hires. But I do believe they said they were going to kick up the enforcement in 2024, but I could be wrong about that. But again, I'll put a note about that in the follow-up email to everybody as well. So it looks like those are questions. And yes, one more came in. We can share the link for the webinar regarding accommodations, including mental health accommodations, when we follow up with everybody. But otherwise, it looks like that is it. Thank you very much for attending today. We've got a lot of other exciting content coming over the rest of the summer and into the fall. So I hope you'll join us for that. But otherwise, I will hand things back over to Brianna.
All right, thank you, Paul. To learn more about MP's full service solutions for 2023, I just dropped a link in the chat that will connect you with an MP team member. You can also visit our website at mp-hr.com for more information. Be sure to join us for our upcoming webinar, Wage and Hour Lawsuits, Prevention, Best Practices, and Legal Advice. Visit our website to register and to see the full calendar of upcoming events and available resources. We will be sending out a recording of today's webinar with the presentation slides this afternoon. Thanks for joining us and have a terrific day.